Good evening, students. Today we will discuss a case wherein the insanity plea has been taken by an individual, and the Supreme Court discusses the burden of proof which is required to be fulfilled in these kind of situations, and explains that why are certain immunities or protections given to individuals who are of unsound mind. Now, in this particular case, the short set of facts which we must know is that this is the case Dashrath Patra versus the state of Chhattisgarh. So, what is relevant and what we must know that this is an appeal where there was a conviction for the offences under section 302, 352, and 201 of IPC. What really happened in the situation, or what has been provided to us in the case, is that this individual approached two individuals who were working on an agricultural field, and the accused, was holding an iron pipe and assaulted the deceased on his head. After which he went and chased after the second person who was present along with the deceased. The trial court stated that this was a situation where the individual must be punished under 302 and convicted him with the punishment of life imprisonment. And the High Court confirmed the decision. There was a submission which was put forward in the High Court that there is sufficient evidence on record to show that this accused was of unsound mind on the date of the occurrence, and that there was enough evidence through the prosecution witnesses which the High Court negated and said that there is a medical examination of the accused which took place, and that shows him to be a normal individual at that point in time. What has to be noted is that this medical examination took place in 2023 while the incident was of 2018. Right. Now, bearing this in mind, what is interesting in this case is that the court has also quoted, and the submissions also involve the reference of all the landmark decisions in relation to the insanity plea under section 84 of IPC corresponding to section 22 of BNS. Now, the first case that is referred to and which points out very clearly that this is the case of Dayabai Chaganbai Thakkar, where it talks about the doctrine of burden of proof, firstly stating that the prosecution has to prove beyond reasonable doubt that the accused had committed the offense with the required mens rea for the offense. And this burden of proof remains throughout from the beginning to the end of the trial. So the prosecution has to prove beyond reasonable doubt, in case wanting to create liability on the individual, that the accused had the requisite mens rea for the offense. Now, on the other hand, the accused can rebut the presumption that he was not insane at the time of commission of the offense. He can plead insanity and under 84 of IPC. Now, this he can do by placing evidence in front of the court or submitting the same to the court, and this proof or the burden of proof in this context is no higher than what rests on a party to a civil proceeding. Now, it is additionally highlighted, and which is of most relevance in this case for us, is that the accused is not required to establish conclusively. It is enough if he creates reasonable doubt that it is a possibility that he was insane at the particular time. It states that the evidence placed before the court by the accused or by the prosecution must raise a reasonable doubt in the mind of the court with regards to one or more ingredients of the offense, including mens rea. In such case, the court will be entitled to acquit the accused on the ground that the general burden of proof resting on the prosecution has not been discharged. So we realize that the prosecution has to prove beyond reasonable doubt. The accused, if pleading insanity, has to create or has to fulfill the burden of proof which is present or which is equivalent to any party of a civil proceeding. And additionally, the court re-emphasizes by highlighting this para that in context of the insanity plea, as long as a reasonable doubt is created and that one or two of the ingredients which have been mentioned, including mens rea, if are raised into doubt, it may lead to an acquittal of the individual. The Rupesh Mangar case has also been highlighted and reiterates the fact that the only requirement with regards to the standard of proof in case of the insanity plea is to raise a reasonable doubt. Now, referring to the Surendra Mishra case again, the aspect which is relevant to note is that the court highlights that the burden on the accused is not required to prove beyond all reasonable doubt, but merely satisfy preponderance of probabilities. Right? So he is not or she is not required in case pleading the insanity plea to give the highest extent of proof, but to prove through preponderance of probabilities that there is the existence of enough evidence that one can lead to this conclusion that the person may have been of unsound mind. The Bapu Alias case has also been referred to break down section 84 by mentioning that the person either must be incapable of knowing the nature of the act or that he's doing what is either wrong or contrary to law. Most importantly, the case also provided that the onus of proving unsoundness of mind is on the accused. But where during the investigation there is shown that previous history of insanity which is revealed, the duty of an honest investigator is to ensure that the accused is subjected to a medical examination, and this must be placed before the court. And if this is not done, it creates a serious infirmity in the prosecution case, and the benefit of doubt has to be given to the accused. Simply put, it implies that where we see history of unsoundness in an individual, there must be a medical examination. And if that does not take place, it is an infirmity in the case. It creates an infirmity in the prosecution's case. Now, based on these decisions, the court highlights that the burden to prove legal insanity is on the accused. It is enough if reasonable doubt is created about the mental state of the accused at the time of commission of the offense, and the standard of proof to prove insanity is only to create a reasonable doubt. Now the court points out to the punch witness 1, who says during the cross examination that this appellant used to get attacks of madness, and also mentioned that people knew about this mental condition of the appellant. Punch witness 2 also mentioned the same regarding him having a history of a mental condition. There was also mention by some of the punch witnesses in this case that he would also try to harm the villagers apart from showing mental instability in his behaviors. So, multiple evidences were provided to show and were deposed to show that the person was suffering from a mental illness before the incident took place, and in fact the villagers were aware of the same, and he had tried to harm them on previous occasion. The court highlights this part. It says that the depositions show that this was his condition before the occurrence of the incident and even after the occurrence of the incident. The court further highlights that they are surprised to note that after the evidence was recorded, the prosecution did not move the trial to take permission for a medical examination of the appellant. And at this point, the court states why protections are given to individuals of unsound mind. It states that the law lays down that no act done by a lunatic is an offense, and the reason is that a lunatic is not in a position to defend himself. The right to defend a charge for an offense is a fundamental right guaranteed under Article 21 of the Constitution. And since a person who is a lunatic is not capable of defending himself, such person has to be protected under the law. Now, the court also clarified that the medical examination which took place after 5 years and therefore is meaningless with regards to his mental state at that point in time when the incident took place. Therefore, court looking into the depositions of the witnesses which they had highlighted are of the view that this is a case of more than a reasonable doubt of insanity or unsoundness of mind on the behalf or in context of the appellant, right? And therefore benefit of doubt has to be given to the accused. This led to the appeal being allowed, and in this situation the appellant was forthwith set at liberty, right? So, to summarize the case in simple terms, the court said that there was enough evidence which pointed out there were multiple depositions which showed that he had a history of mental illness and that the villagers were also aware of the same. This pointed out at his mental state before and after the commission of the crime, and this was more than enough to create a reasonable doubt, creating a benefit to the accused, and therefore the appeal was allowed and he was set at liberty. So, a short and small decision which highlights all the important case laws for the insanity plea under Section 84 of IPC. And also, in short, quickly, the Supreme Court has also told us why the insanity plea is provided to accused suffering from unsoundness of mind, right? I hope students this video helps you, and in case you want me to take any other cases or topics, do let me know. Thank you so much students. Have a great evening.